Thank you, Mr. Speaker. And I appreciate the good lady's kind words or multiple of my colleagues and the kind things they've said. And this isn't personal. I mean, it is, obviously it affects my life, but I don't believe in taking anything personal. I don't believe in harboring grudges or ill feelings. I think it just discourages everything. So I'm not standing up here debating because of what this does to me or anybody else I know, or I'm debating solely on principle, and that's what I told the good gentleman that was spearheading this bill, is that I would vote against this like I do any other bill that increases regulation and goes against the principles that I hold dear of freedom. I wanted to, and I'm not here to attempt to filibuster and drag this out. I think I covered everything that I wanted to in my first argument. I appreciate the motion from the good lady from District 7 to send this to the amending orders, and I didn't stand up in time to debate that, and I'll tell you why. I think all of us agree in the transparency aspects of this, and I think the medical providers agree as well. They want to, they're doing their best. Are there regulations we could get rid of? Insurance regulations, things we could do to simplify their jobs? I think there probably are, and I think we should look at those things, because every year we hear we're into helping reduce healthcare costs. Those are the things that would reduce healthcare costs, not this. And one particularly problematic part of this bill is something I didn't cover last time, is section, actually I'm going to come back to that. There was some debate about sending these to small claims. And what people have to realize is, in collections, getting the judgment is usually not the hardest part of collecting the debt. They can hire somebody to go to these small claims. You know, they're going to pass the new employment costs on to the patient, obviously, because they're hiring somebody now to do small claims because they can't get an attorney. But then what happens after you get the judgment? That's when the real work comes in. I'm hired by other attorneys to collect judgments. I've got attorneys that get their own when they're not paid fees, and they hire me to go collect them, because that's really where the expertise in understanding the laws comes in, is after the judgment is obtained. Every attorney knows how to go out and fight a court case and get a judgment. There's not a lot out there that will take the time and have the systems in place to collect on the judgment. So these small claims judgments that somebody may or may not get, they've also now got to have somebody to manage those and go out and do all the stuff. I mean, it's an arduous process to collect once you have a judgment. A lot of the reasons that also makes the $80 that attorneys get laughable after filing a lawsuit, because that's got to include all the post-judgment work. Now, there are some provisions in here of extraordinary, if it's grossly disproportionate. There's some new legal terms in here that you can go back and seek attorney's fees, but for the most part, that $80 doesn't cover the lawsuit up front, so they're not going to be able to find counsel. But even if it goes to small claims, there's no way to get those fees. It even caps. We have specific laws in place on how much the sheriff can get for garnishment. If somebody contests a claim of exemption, the prevailing party at those fees has to pay those fees. And this even limits the cost of obtaining a second writ of execution, $25. This means people have the judgment. They clearly know they have the debt at this point. But then they're even limiting the fees. All they have to do, my clients, I recommend, base it on budget. Whatever they can pay, plus they've got cases where they're taking $5 a month, and they have for years. And in committee testimony, you heard from a gentleman that was upset that I let him pay $10 a month for a long time, and it wasn't covering the interest. Well, I did that because I went over his budget, and I said, I'll allow this. I'm not going to garnish somebody that's making an effort, and it looks like based on their budget, they're making an effort. So all of us agree on the transparency part of this and helping reduce the cost of health care. So maybe those first few paragraphs are okay. Again, I don't like the dates. I personally believe all doctors are trying to get these bills out. Now, we heard from some what those dates do, those deadlines, though, is maybe they can't comply because of changes in insurance or people move. And if you've ever dealt with insurance companies, the good gentleman from 35 knows how this is. I see bills that they went to the hospital, they changed insurance the next month, and it takes 3 months to sort it out. And now we're telling these doctors that, hey, if something like that happens outside of your control, you're going to lose all these rights to go collect that debt because you couldn't possibly comply with those. And it says, well, you can go ahead and take regular collection methods if you miss this, but you can't do the extraordinary stuff. Well, sending a letter obviously didn't work, or they wouldn't be to that point. Now, on to a very strong argument I believe that I didn't talk about. If we all believe that the intent of this bill is to increase transparency, we've already talked about then why cap attorneys' fees, why limit access to the courts, and I think we all know why. Section 48.3.11, enforcement and civil penalties, is especially troubling, and it should be troubling. What we're saying, and first of all, it's not even clear any party takes an extraordinary collection. So does this apply? Is it double whammy? Does the collection agency who doesn't know, the collection agency will never know if the doctor complied with these. So the Idaho Collectors Association came in and opposed this, and that's one of their concerns. The FDCPA has what's called a good faith exemption. So if somebody inadvertently sends letters out to somebody or has the wrong amount or something, they can go into court when they're sued, by the way, which is a one-way attorney fee structure. If you win an FDCPA suit against you, you don't get anything, and if you lose it, you have to pay their costs and fees. But that is what it is. But the good faith exemption, this does not have anything like it. The Idaho Collection Agency Act has a good faith exemption in it, so that if a mistake is made, there's not legal liability. You have to pay attorney's fees, but that's about it. So section 48.3.11, I'm guessing this applies to both the collector and the medical provider. It clearly applies to the medical provider. So if any party takes any extraordinary collection action other than in accordance with these sections, then, notwithstanding any provision or law or agreement to the contrary, a patient shall have no liability to pay for any collection costs, expenses, fees, including attorney's fees. Okay, guess what? That's already the law. If you win a lawsuit because nothing was owed, you don't do it. So that's not a big deal. Subsection 2, the party is liable to the patient in an amount equal to actual damages sustained by the patient as a result of the failure to comply, or $1,000, whichever is greater. If you own a business and you've got exquisite record keeping, which doctors do, I've never seen a lawsuit I have filed that I haven't been able to go to them and get exact dates that they sent the letter. It's all there. In fact, a court has never found. I have one case out of 10,000 cases that they found that they had the wrong address, and it was Skyline instead of Skyview Drive or something. And guess what? We didn't win that case, and we had to pay his attorney's fees. Every other case out of the 10,000 I've ever had, we've been able to prove with the medical records that the doctor sent the statements, multiple statements. Now, we heard several stories, heartfelt stories about being sent to collections. I agree with that. This bill is not designed to protect the unintended consequences of this bill. Like I said, those people in collections, it sucks to be sent to collections. I've been there myself twice. One of them from a client of mine. So I get that this can happen, but you know what happened with that? I called and I said, hey, I just got a collection notice from you guys. Yeah, we got it. I called the provider. It was a subcontracted nurse with the hospital. There is no harm done there. I got the letter, I called, I fixed it. They billed the insurance, I paid the rest. That's what happens when you get to sent to collections. There's no fees or costs added when you get sent to collections. There can't be. Those collection agencies are, again, holding the bill for several months usually, trying to collect through sending letters, phone calls, before they... So all these horror stories, getting to sent to collection doesn't cost anything at all. So I get that it's tough, but that's not what this is designed to stop. This enforcement and civil penalty, if a doctor, like I said, back to the records, they keep very good records. But if they make any mistake now, one of the required letters doesn't go out, or it's 46 days instead of 45 days, or the address moved, and there's a real question with the language here on what the address should be, last provided by the patient. I litigate these cases on a daily basis, and there's always an issue. Did I give them well, here's your sign-in form, it's here. Well, I moved. Well, I'd been there 2 months ago, and I didn't update it this time. The burden of proof being on the doctor now to show this, I mean, typically they prove it just to show it, because we get this excuse. I've gotten this pile, and I can't share it because we're on the floor. I've got a case going to the Supreme Court here pretty soon. It's not scheduled, but it's going through the appeals process. And the gentleman has an affidavit, one of the things I was going to show the committee, where he says, I didn't know about this bill before I was sued. So I've got the affidavit and computer records that cannot be altered, telephone records that cannot be altered, to show not only did he get the notice, but when he talked to the staff of my client, he told them basically things that cannot be repeated here, and now he's saying he didn't know about it. And I've got 2 other cases that were in mediation with these same attorneys that have been hired in this thing to argue with us, and we're sitting at mediation in 2 cases, and they told the mediator, well, they don't think, basically we're negotiating attorney's fees and coming down, and they told the mediator, we didn't know about this before we received the bills. I showed the mediator, well, let me show you some telephone records and some bank records in both cases. Not only did they not know about it, they called my client, they set up a payment, they made the first payment and stopped. How does that affect your mediation? Like, this is something we hear all the day. Maybe they forgot. It's been 6 months ago since they got the letter and called, but I hear that again and again, and I'm sorry, doctors can make mistakes, but for the most part, they're getting this out. So that 48-311, I wish this had went to general orders, because I just think it is fundamentally wrong that we're telling a doctor, if you accidentally send it the 46th day or forget or have a wrong address or anything, you've now got to pay them. And it's not just the actual cost. Maybe if it said they'd have to reimburse the actual cost, that's maybe a court fee, the filing fee, whatever. I get that. Make them whole. But it says actual cost or $1,000, whichever is greater. And this isn't if they did it intentionally. That's the section if it's done accidentally. So now you've got medical providers paying fines and fees because they maybe made a mistake or they can't prove that they did it the way they are. That's insane. And to make it worse, if you do it willfully, and I probably wouldn't even complain about the willful section, but to show you that it's intended to punish these doctors that make a mistake, the next section is $3,000 if you do it willfully. I'm actually okay with willfully. If you willfully disobey the law, you should probably do it. But we're creating a $1,000 penalty for medical professionals if you accidentally don't do one of these things that are in 5 pages of regulations. So go get your attorneys, medical providers, figure out a new system. But it's going to reduce costs. Right. I just have a hard time believing if anybody can tell me one regulation that has ever reduced costs, I'd be happy to listen. But I really have a problem with that $1,000. And so, unfortunately, the motion to send it to general orders failed. I think that alone is severe enough to stop this bill, let them come back and do a redraft where they're not punishing our medical providers for making a mistake. There's already what's called in the collection industry, there's cottage industry set up. This state, it's not too bad because we have the Idaho Collection Agency Act and we already have other protections. But around the country, there's a cottage industry of attorneys that routinely sue these because of the one-way attorney's fee provision in the FDCPA. So you just look it up, cottage industry, go around the country, and what they do, they sue collection agencies for FDCPA violations. A lot of the times, because they know it doesn't pay to fight them, and here's what happens. They come in and they say, okay, we'll withdraw our suit, and we'll give you $500 because we can't get our attorney's fees even if we win. It's been debated for 20 years, should they fix that? And it's not a very sympathetic industry, so nobody wants to look at that and do it. Myself, clients I've represented at least 30 FDCPA claims against us in the years I've done it. Most of my colleagues will just pay it out. They work for larger collections agencies, multi-state collection agencies, and for them it's not worth it paying an attorney to do it, so they just pay $500 to make them go away. That's literally a practice that happens. I can tell you attorneys that do it in the state of Idaho. For me, my clients are small, locally owned providers that can't get in that habit because it can get costly. So we fought those. We've won every single time because we haven't made a violation, and I appreciate that. I believe the sponsor of the bill mentioned he didn't see anything illegal, and that's not what I'm arguing, but I'm arguing already it's so risky to make mistakes. And now you add this, that there's no good faith protection, there's no, hey, the doctor made a mistake and sent this 46 days later, or hey, he had the address as Skyview or Skyline. He now has to pay a $1,000 fine no matter what they did, which is just, if this is the intent of the bill, that provision alone is scary. So with that, I'm sure everybody's hungry. I would encourage everyone to vote no.